Bruno Lira, a defendant in Salucci and Ciali v. Color Image Apparel et al., was served by depositing the complaint in her Instagram DMs. Yes, the attorney slid into her DMs. She also received service, though, via her email. When Liro failed to respond, the Northern District of Illinois entered a default judgment against her, as is the standard civil procedure. Now she's challenging the default, asking for more time to respond to the original complaint. And surprisingly enough, the plaintiffs actually aren't contesting that. And if you think that's unusual, I want to highlight that WikiLeaks received an effective service by tweet 8 years ago. And some people might be surprised to know, but service by publication is an option, which is a legal method of giving notice to a defendant when you can't locate them through more traditional and conventional means like personal delivery or mailing, which ironically is why Bruno was probably served by sliding into her DM in the current case. Instead of handing them the lawsuit, you would publish a notice in a newspaper or other publication that's reasonably likely to reach them. And since newspapers are fading away, what would the modern equivalent be? Like, could I just post on my Instagram story with the service of process, knowing that the defendant follows me and should reasonably see it? You know, the law does need to adapt to modern mores and technology. And more, I would honestly argue that a more younger defendant would probably be more likely to see a complaint slid into her DMs than, say, published in the Tennessean. It's an interesting argument and an interesting case. Thanks. Have a good night.